Hello, everyone. Welcome to this episode of our Legal Pathways podcast. I'm your host, Charles Bowen, and I'm delighted to be here this week with our good friend, Ken Menendez. We'll be talking today about law firm success in the 21st century, how AI and technology are helping law firms work more efficiently, and how even in change environments, leadership is still a bedrock of professional service, integrity, and success. Ken is a partner at the Atlanta office of Freeman Mathis and Gary. They're an AmLaw 200 law firm with offices in more than 21 states. Ken graduated from Vanderbilt University and the Northwestern University School of Law. Ken also is the author of the book Taming the Lawyers, which he adapted and hosts as an 8-part series on Georgia Public Television. Ken practices in the area of complex litigation, including construction, employment, and financial and commercial disputes. Ken has a Martindale-Hubbell rating of AV, which is their highest rating, and has been recognized by Chambers USA as a leader in the field. He's also included in the Best Lawyers and the Georgia Super Lawyers. Ken also has served as an adjunct professor at Emory University School of Law, where he taught alternative dispute resolution, which we'll call ADR. Ken is an advocate for effective and innovative resolution of disputes and client matters. So consistent with this philosophy, he's a certified arbitrator with the American Arbitration Association. Ken, welcome. It's great to be here with you today.
Charles, thank you for having me. Look forward to our conversation.
Yeah, me too. So this week we're talking about the important role of law firms in the professional services ecosystem and how law firms contribute to the quality, breadth, and reach of innovation, efficiency, and delivering legal services. But as most of us know, there's been a lot of changes in the profession and the practice of law around the past 10 or 15 years, and including technology, building nimbleness, delivering on collaboration. As someone who's been involved deeply with law firm leadership and client service, I appreciate your willingness to talk to our listeners about this today. So, in line with that, one of our key themes of this podcast is to identify solutions that draw on creative thinking and the ability for innovation. And writers and commentators have been talking about this for the past 20 and 30 years, including yourself in your book, Taming the Lawyers. Love to talk to you for a minute about your thoughts and rationale for writing that book, which more than 30 years ago was really ahead of the curve on many of these topics.
Of course, 30 years ago, I had no idea exactly where the curve was going or that I would be ahead of it. But what led me to write the book when I did was that at that point, I had enough experience being in law firms and working with companies that I saw some significant inefficiencies in the way things were progressing and the way things were handled. And so I thought that I might at that point be able to offer some suggestions for ways in which clients and lawyers could work together more effectively and maybe get around some of the problems that are inherent in the relationship between lawyers and their clients.
Yeah, and I call that bridging the gap between professionals and laypersons. And some of the themes you talk about in your book, like using ADR, using project planning, we're way out in front of current trends of project management and e-discovery and streamlining the ways that we compile information and get ready to address our clients' projects.
I think that's true. And I think the situation has only gotten more acute over the years that I've been practicing law, in part because all of the things that we lawyers do in private law firms have become more and more detailed and therefore more and more expensive. And so when that occurs, I think what happens is that the thoughtful client is looking for ways to continue to get a quality legal product, but to do so within the parameters of whatever the cost issues are that they are facing. If we are just left to our own devices, we in law firms can run amok pretty quickly.
One of the things we talk about is the cost of legal services, like you alluded to. And there's a phenomenon that's called Baumol's cost syndrome, which Baumol. And Baumol and Bill Bowen, who was the president of Princeton University, talked about the reason for the inflation in professional services when we're seeing deflation in other areas like television sets and computers and technology. Do you have any thoughts on why legal remains sort of an expensive proposition?
Well, the unserious response would be because we can. and because people will continue to pay for it. I think the more serious response is as the legal landscape has gotten more complex, you have to do more work in order to make sure that you're right. The thing that sometimes business people forget is that most lawyers in private law firms live in complete and total fear of getting it wrong because every day our job is to get it right. And every day there's somebody on the other side of the case that's trying to prove that you did it wrong. So that requires more and more preparation. That requires more and more covering the landscape in terms of making sure that you're not missing anything. The thing that lawyers wake up in the middle of the night worrying about, believe it or not, is what have I missed? I think I've got this thing doped out, but what have I missed? So the fact that the landscape has gotten so complex and so deep has required lawyers to go longer and deeper. And since we oftentimes bill on the basis of how much time we spend on something, that leads to a lot of the price inflation.
So one of the themes we'll talk about a little bit more are ways where we can try to reverse that trend through working efficiently, through leveraging technology, and bringing other resources in that may not be as high priced as a fully loaded legal professional. So with that, I want to jump into our topic du jour for 2025, which is artificial intelligence. And especially since the splash of large language models on the scene almost 3 years ago now, we now have GPT-5 and Harvey and other AI tools that lawyers are starting to use to augment and help deliver knowledge resources as well as even drafting and memos and things which can provide an efficiency in starting out our work. So I want to talk to you about how law firms are using AI to try to make inroads in those areas. So, one of the things we have flagged is that surveys show that law firm use of AI has grown since 2023 from 11% to 30 plus percent. And that's per the Thomson Reuters research in April of 2025. Is this a trend line that you're seeing in the practice groups that you're working with?
It is. And of course, I do mostly commercial litigation. And so a lot of what people in my part of the business do is they use AI to do legal research, but also to do things like collate documents, go through large stacks of documents and determine what's in them and what have you. Uh, I think those numbers from Thomson Reuters are exactly correct and probably understated a little bit. Law firms are picking up on this with great speed these days. And even over the last 6 to 9 months, I have seen an increased use of AI in many facets of the law firm practice.
You know, it's almost unavoidable because we use it sometimes even for free in our personal lives for calendaring, for reminders, for writing, dare I say, letters and correspondence. So it's almost inevitable that that's going to spill over into the workplace. And my view is that once people can see areas where you can have efficiency with a low risk of quality control, it's almost a no brainer to start with it for some types of projects.
I think it really is, and I don't want to hit this one too hard, but I think it's almost analogous to the revolution that took place when email came into widespread use. At first, if you'll remember, people were kind of reluctant to use it. And now, of course, it's unthinkable to anybody in business not to use emails. I think that's what's going to happen with AI. I think it's going to become much more prevalent on a day-to-day basis. And I think as it does so, people will learn how to use it more effectively and more safely, because as we've already seen, there are instances where the use of it in an unthoughtful way can lead to some significant problems. But as people become more familiar with it, as the experience curve allows us to see where the pitfalls are, I think that you'll see more and more use of it because in many instances, you can't compete with it. It's too fast and it covers too much. And so to sit in your office and say, well, I'm not going to use that is probably no longer going to be a viable option.
Yeah, any knowledge tool that's trained on a multi-terabyte training set, which basically includes the whole internet, the whole Wikipedia, non-proprietary, unstructured legal databases, case law. It's hard to train oneself with that broad of a data set.
Well, you just can't do it. You just can't compete. And we've already seen instances where, with regard to organization of documents and things of that sort, even prior to AI, computer-based systems being faster than the humans. A paralegal assistant can't keep up with what a computer can do in that particular regard. Now, the computer still has to be trained to do it in the right way, and you still need the human touch to that. But just in terms of the sheer review of documentation and organization of it, uh, we can't compete.
Yeah, technology just scales up in a way that a human being cannot. Once you invest the money to train the agent to review documents, to create precedent forms, etc., then you can deploy that, and the more clients you can deploy it to, the lower the cost.
Exactly.
Whereas you and me, when we go to start on a project, we can't scale ourselves up to effectively reduce our incremental rate.
Not yet. Not yet.
Yeah, that and if you and I are around for another 20 years, we could talk about cloning or digital twins or something where that might be possible.
Exactly.
Yeah. So talking about the quality, the QA element, our friends at Russell Reynolds in June released a survey of more than 2,000 law firm leaders. And no surprise, just like we've alluded to, 75% believe that AI is relevant and important to the future of their organization, but only 41% believe they have the skills to use it today. So, if we accept this trend line, how do we make sure we're using it in a way that's appropriate and with the correct guardrails?
Well, I'll begin by saying that 41% sounds optimistic in terms of the lawyers that I know being able to use it. I don't think we're quite there yet, but I would say this, and it sounds sort of facile, but what it means is that we're going to have to identify and rely upon the people who are the experts in this field. Now, how do you become an expert in the field that's so new? You have to get out there and try it and do things. But one of the biggest things that we learn as young lawyers is don't try to do things that you're not qualified to do. And I would say that with, perhaps a sizable minority accepted, most lawyers aren't particularly well qualified to determine how to use AI at this point. Now, a year from now, that might be different because the curve is accelerating so rapidly that it's something that we're going to have to do. So there'll probably be a lot more of us in the future who learn how to do this. But the fact of the matter is, at this point, somehow, some way, either through business or some other way, we've got to identify the people who can actually teach us how to handle this stuff. And then we got to try it out, use it, and do so, some beta testing or whatever it is that we need to do so that we can use it without hurting our clients or going into court and doing something that we shouldn't be doing, but figure out how to use it. The experience is the best teacher. So, short answer, find the experts, learn from them, and then implement it ourselves.
Yeah, great thoughts. Like a network effect, the more users, the more likely there are we'll have educated users who can train others. Ken, as we think about the people aspect, the people who are using AI, what about the concept of AI displacing lawyers or legal professionals? Goldman Sachs released a very famous prediction back in spring of 23 that legal could be up to 44% displaced by AI. They've just in the last 3 weeks updated that to roll that number back to 17%. My sense is that's because we haven't seen that type of displacement. We're seeing more augmentation and human machine partnerships. So but the jury's still out about what's going to be the effect on headcount and staffing and opportunities for new lawyers. Do you, what's your take on the places where AI may be displacing people and who could be at risk?
In my experience, it hasn't happened yet, but I think it is going to happen. I think the place that it's going to hit the hardest is going to be with the people who are, quite frankly, the youngest and the ones who are first getting into the practice, because those people in a law firm are the ones who are typically asked to do the tasks that AI is best at doing: legal research, document organization, distilling information from large databases, things of that sort. I think the reason that that number got rolled back, other than they started talking to a bunch of lawyers, is the fact that lawyers and law firms are inherently conservative in one respect. We're not going to go out and fire a bunch of young lawyers just because we hear that AI can do their job. What we'll probably do is hang on to the young lawyers and then try to integrate the AI into the system. And then at a certain point, if we see that it can displace those young lawyers, then we'll start to cut back on the young lawyers. Same thing is going to happen, I think, with paralegal assistants. Those are the two places where you're going to see the effect most tellingly and earliest.
That's probably the direction where we're headed. One thing I like to think about is, are there ways we can redeploy people from what I'll call low skill tasks like research and fact gathering and compilation into more things like client advice, preventative risk management, and other areas where we can actually turn some functions over to the AI and then let people deploy that subjective judgment and reasoning on other tasks.
I think that's exactly correct. And the question is, at what point does the young lawyer have enough experience to be able to advise clients in a fashion that's helpful to them? But again, going back to the law firm model, we spend a fair amount of time investing in the young lawyers, training them, first of all, identifying them, recruiting them, training them, and what have you. You don't want to just let those people leave if you can find another way that they can provide value to the client. And so that then puts the ball in the court of law firm leadership to identify the things that the clients need and to see whether or not those younger lawyers can be recast into people who can provide that to the clients. We're a very reactive industry. We provide the clients what they need. We provide the clients what they need to have addressed. A lot of people say, well, how did you become an employment lawyer? Well, my clients needed employment advice. So I became an employment lawyer. And so as we try to figure out how to hang on to these people and not completely displace them, I think it's going to be up to law firm leadership to be a little bit more creative, working in tandem with their clients.
Yeah, clearly clients are or should be in the driver's seat about how we service their projects and how we deploy our headcount. So definitely, it sounds like a client firm process going forward.
I think that's right. And I think that if the clients and the law firms continue that conversation, they'll kind of surprise themselves at finding some of the things that they can use those lawyers for rather than just sitting in a library doing research.
Yeah. So what we think about how we use lawyers as headcount. What about the use case for AI in general? If AI is making law firms more efficient and saving time and saving some of the human capital resource, what's the incentive for law firms to use AI? Wouldn't it be more profitable in the near term for lawyers like you and me to just keep billing our regular time at our regular rates and leave these tools on the side because we're able to leverage our billing rates and increase profitability for the firm. Can AI coexist with that type of desire to run a for-profit business?
Not for long. I think the answer to how long can we continue to do it that way? We can continue to do it that way until the law firm down the street with whom we're competing starts to use AI and starts to provide the very same services that we're providing at a lesser cost. Because you have to keep in mind, and I'm sure most of your listeners know this, but most law firms bill on the basis of time spent. So that if I can bill for 5 hours, that's better for me than if I can only bill for 3 hours. Unless, of course, my competitor down the street can get the job done for 3 hours at more or less the same rate. And then my client goes to the person down the street. The fact of the matter is, as AI gets more ingrained into what it is that we do, the cost of doing certain things ought to go down. If that cost goes down, that ought to make me more attractive to the client and we hope get more business from the client. And therefore, instead of working on 2 cases, I'm now working on 10 cases because I'm more competitive and I cost less.
Yeah, so this may be one of the answers to that cost dilemma we talked about earlier, where AI combined with your skills in using it can actually drive down the client's cost.
I think it can, and I think at a certain point, there'll obviously be some resistance to that in some quarters, both in terms of law firms and clients, but mostly in terms of law firms. But the idea is, what is it that I can do for my client and provide the best service at the lowest possible cost? If I continue to do that, I'll have plenty of business because that client will give me more business if I'm doing a good job for them at a good cost. At a certain point, if I'm doing a good job for them, but I'm 3 times more expensive than my competitor, they're going to stop sending me the work. And so at that point, you've got to address all of that. I used to have this conversation with some of my partners in an old law firm all the time. They would say, we should only take work that is, $700 an hour. And we shouldn't be using our lawyers for anything less than $700 an hour, and therefore stop those lawyers from doing that $200 an hour work. And I would always say to them, that's great if we have all that $700 an hour work. But if we don't, I can't keep that person over there waiting for that $700 an hour client. I want them to work on the $200 an hour client because at least I'm getting the $200 an hour. So it's just a matter of whether or not the client is willing to pay you for what it is you're going to provide. And most clients are smart enough to understand that they only want to pay for something that's valuable and competitively priced.
Yeah, that's really interesting, Ken. I've got two reactions to that. One is a great article by Ron Dolan at Harvard Law School from 2022 called "Adaptive Innovation in Law Firms," and this idea that we can all stay in the tippy top perch on Mount Olympus and only take the eagles that fly into us with big high dollar cases. That's just not realistic because every organization from Oracle and Apple and Microsoft on down to a mom and pop, they have a whole range of legal issues. So you put yourself in one niche, that's a great place to be, but it may not be something that every law firm can bet its future on.
Well, that's exactly right. I mean, everybody wants to just service the eagles, but there's only a limited number of eagles. And when they're flying around out there, all the other law firms see those eagles too. So, yeah, there's going to be competition for that high end dollar. There's also an awful lot of work that gets done for less than the top end dollar, and it's important work on behalf of very good clients and very good companies. So, it's fine to say I want to get the highest dollar value and the highest dollar work, but there's an awful lot of room in the market to do a lot of good work at something less than that tippy top.
Yeah, and this sounds like a cliche, but anything that's important to my client is important to me. And I want to make sure I can do it not just well, but also efficiently.
Well, there's no question about that. And just to push that point for 1 minute, sometimes it's the smaller businesses, and I typically represent businesses, so that's my background. But sometimes it's the smaller businesses that have more to lose when they get involved in a dispute or whatever it is that they're trying to do. The largest companies in the world, they can absorb a bad decision, a bad loss, what have you. Sometimes a smaller company, it's an existential threat. And so I'm not saying that you work harder for one or the other, but what I am saying is sometimes it means more to the smaller company because it represents a larger percentage of their overall business plan and revenue stream.
Yeah, the stakes may be higher.
Right.
So, Ken, the other thought I had in this point was the concept of client empowerment. So, one of the things we've seen over the last 5 to 10 years is clients taking a more active role in scoping and procuring legal services. In fact, a couple of clients I work with actually have outsourced some of that procurement to their corporate supply chain or procurement group. And as a result, we're seeing things like RFPs or requests for proposals to
Hmm.
different law firms to bid to perform legal services. So, you know, that type of competition to me makes it imperative to be able to present your most efficient, best price to get the work.
We see a lot more of that, whether it's a formal process with a larger client or just a smaller company that decides to talk to two or three different lawyers. Uh, I think in the end, it's a good thing for the legal profession because it keeps us on our toes. Competition makes you better. And it forces you to take a look at your systems. Am I doing this the right way? Am I providing the highest level of quality? Am I doing so in a way that allows the client to purchase it? You know, we can sit around all day and talk about the quality of what we're providing, but if nobody wants to buy it, then it doesn't really make any sense. I'll just tell you this real quickly. Years ago, I was interviewing a young candidate for a law position, and the fellow, I said, "So why do you want to be a lawyer?" And he said, "Well, I just hate sales." And I said to him, "You don't understand. If you're going to work for a private law firm, you're in sales. This is what we do. We are selling what we put together to clients who are willing to pay for it." And so I think in the end, this development of competitive selection of lawyers, which is really accelerated over the last 15, 20 years, is probably a good thing. It makes you sharper. It makes you better. It makes you look at what you're doing and see whether or not it still makes sense. Because remember, all of us lawyers, we were trained for 3 years to be lawyers, not business people. And so, therefore, in the private law firm world, we're oftentimes dealing with our clients with 95% of our brain, and with 5% of our brain, we're thinking about running our business. So, something like this that forces us to look at those things just makes us better. And in the long term, is probably very good for us.
I think it's good for the profession too. This is way off topic, but the National Conference of Bar Examiners is rolling out what they call the next gen bar exam that's going to roll out next year. And in addition to standard questions on subject matters like contracts and torts and trusts and wills, it's also going to include questions on practice related skills like interviewing, client development, and professionalism.
I think it's a good idea. And again, I'm speaking from a different age, but when I was in law school, we spent very little, if any, time talking about the business of law. And that's understandable. We're not there to learn how to be business people, we're there to learn how to be lawyers. But it would seem to me that some of that would be a good thing to happen in law schools. And I have a sense that it is happening much more in law schools now than it did back when I was in law school. But you have to do that because 95% of the lawyers, when I came out of law school, when we came out of law school, we had no dreaming idea about the business of law. And so you had to learn it through experience and trial and error and what have you. But I think a little bit of education in that regard would be good. And I think if they're making that part of the bar exam, that's all to the good. I just hope that they're not dumbing down the bar exam in ways that I've heard that they are doing.
Well, we'll see when we see the next crop of
Well,
graduates.
that's right. That's right. Every time I run into a bad lawyer, I always tell people we got to make that bar exam a little harder.
Raise the bar, so to speak.
Yeah, right.
So, Ken, as we continue to talk a little bit more about AI, how about the risk of things we've all heard about in the area of QA and quality control around hallucination and inaccuracy? Things like the famous brief in Avianca Airlines, or the more recent brief in the Anthropic AI expert witness case. What types of risks do you see in using AI, and how do we mitigate that? How do we make sure that we can use tools that are efficient, but also keep quality control?
The risk is, yes, the obvious one, and that is substituting AI for human discernment in terms of what actually gets turned into the court, what actually gets put into the brief, and what have you. It's going to become actually a bigger problem as we go forward as people rely on AI more than they have in the past, because the risk that I see, quite frankly, is that the young lawyers, who are the ones who are doing most of the legal research in most large law firms, the young lawyers, if they start to rely on AI to the detriment of developing their own research skills and their own analytical skills, will start sending that things to the partners that we won't be able to tell whether it's AI or whether it's them. And then we'll be relying on what happened down the line. In all of the cases that you mentioned, you hear the same refrain from the lawyers when they're finally called on the carpet in front of the judge. Judge, I didn't go back and look at this after the associate gave it to me. I should have done it. I realize I should have done it, what have you. The danger to me is that AI becomes so prevalent that people just rely on it without going back and checking it. So how do you mitigate that, which was the second part of your question? You mitigate that by having the human element overlaid and say, okay, I've got all of this from AI now. I've got to go back and check this. I can't just rely on it, because we know now through bitter experience that AI is going to make things up from time to time or to get things wrong. And so there has to be that human oversight to make sure that we're not just blindly relying on it.
Yeah, the models can only do so much, even with RAG, retrieval augmentation, and other tools. It's pulling from such a vast set of data. It doesn't actually know which are the correct functions. It just knows that it has been trained to respond that if then it's going to serve you up that answer.
I
So
think that's right. Yeah.
it's pulling from a very deep pool, and it's up to us to skim the dross off the top.
It does. Let me just mention one thing. That's going to cost more money, because it costs more for the senior lawyer to go back and check all of that than it would for the senior lawyer to just pass it right along. So that's going to involve and require a conversation between the client and the lawyer to say, look, when you get that itemized bill at the end of the month, you're going to see that young lawyer X did this, but older lawyer Y did that. And let me tell you why older lawyer Y needs to do that. It's because younger lawyer X did it much, much quicker than before. So you saved money there.
Yes.
But now I've got to go back and review it. And so that's where you're going to lose a little bit of that savings. But we would argue you're probably still going to be ahead of the game, because that younger lawyer might have done a job in 5 hours that heretofore would have taken 25 hours. So look, you saved 20 hours at that rate. But now I'm going to have to put in 10 hours at my rate to figure out whether or not it's all correct. And by the way, we have to do that in order to meet our obligations to the bar, to make sure that we're not submitting to the court authority that's not correct.
Yeah, that's a very succinct and cogent way to explain it to the client. And last summer the ABA came out with a formal opinion on this that was pretty good. ABA opinion 512, and that talked about some of the rubric of our model rules of professional responsibility to maintain our competence so that clients know that we can use tech tools like AI and video conferencing and online research, communication, that we are letting them know that we are using AI and make sure that we have their permission to do that, and a whole host of other um, uh, elements where it intersects with our professional responsibility under the model rules.
Well, I think you're going to see the rules develop in order to address this. As you know, Charles, the law is always a trailing indicator. We're always trying to catch up with technology. We're always trying to catch up with what's going on in the marketplace and what have you. But I think that until that happens, and until we figure out what the new AI rules should be and what have you, the rules that we already have in place ought to, if you apply them correctly, they ought to be enough to make sure that people understand. There are rules in place now that talk about candor with the court. Well,
Mhm.
that covers anything that you put in together that AI has put together in terms of legal authority and what have you. So I think we have the necessary rules in place. Obviously, they can get better, they can get more refined, they can get more specific. But what we really need to do is apply the ones that we have in place.
Yeah, amen. I think the model rules stitch together a pretty robust way of doing business and interacting with our clients. And I think the ABA's opinion 512 does a pretty good job of overlaying AI and giving us ways to think about it in that rubric.
Exactly.
So, Ken, thinking about AI as a whole and law firms, what about law firms as a knowledge management repository? It occurred to me that clients like to keep things in their own wheelhouse and do things their way. But if you're working with a law firm a lot, you may want that law firm to be your aggregator of tech resources for research, for drafting, for e-discovery, for contract management, for IP rights management, etc. And I know you have people at your firm who maintain and who advance your firm's knowledge stack. What do you think is the best way for law firms to be effective uh, aggregators and advocates to be their clients' legal technology resource?
Well, I think that the best thing that you have to do is to talk to the client about what their needs are in that regard, and that is a function of the size and complexity of the business of the client. There are some clients where it would make all the sense in the world for the law firm to be the aggregator of all of that. There are others that are sufficiently large and sophisticated. They're better at doing it than we are. They have better systems, they have better IT people, what have you, and they can come up with a model that they can then hand off to us. The smaller client may well not have the resources to put together that sort of a system in-house. And for those folks, it makes more sense for the law firm to keep all of that and for us to say, here's our package, if you want to call it that. Here's our package of AI, and here's what we do, and what have you. Even when the outside business is large enough to do it, though, I think there's going to have to be some significant conversation and collaboration with the law firm because that outside business may not be aware of some of the legal requirements that only the law firm would be aware of. And of course, that leaves aside in-house lawyers at the big firm, at the big client. They may have every bit as much information as an outside counsel. But if you don't have that overlay to it, then you might be able to run off the tracks a little bit. So it's kind of a wishy-washy answer, but the fact of the matter is it's going to have to be both. It's going to have to be aggregated at the client and at the law firm.
Ken, that's a good answer because it will depend on the size and the sophistication of the client organization. There are some clients that I work with who plug into their tech stack, and others who that they are happy for me to
Right.
do the research on my own platform. Ken, as we talk about clients and putting the ball into the court of clients, understanding that every client's needs are different. What about helping clients manage the cost crisis that we've talked about, helping clients manage their demand? Are there tools and resources that you at the law firm can share with clients to help them identify their needs, mitigate risk, and get in front of problems before they have to come to you?
There are, and I think the biggest one is probably the simplest one, and that's just basically getting involved with some task-based budgeting. What you need to do is you begin by talking to the client about what it is that you're trying to accomplish, and then what are the building blocks that you need in order to get there. And we oftentimes provide clients with a very detailed cost estimate at the beginning of an engagement that says, if we're going to do these many things, here's how much it's going to cost. If it goes this long, how much is it going to cost? And that way the client can understand at each step of the way what it is that they're buying. Lawyers for many years have resisted this notion that we're selling anything, but we are. If you're a private law firm, you're selling things, you're selling legal services. And I always tell the clients, especially on the litigation side, litigation is just a means to an end. Okay. So what are you trying to accomplish here? What is your ultimate goal? And then we can work backwards from that. And once you tell me what your ultimate goal is, then I can break it down into component parts and say, well, if you want to do this, we have to do these 5 tasks, and here's how much they're going to cost. Obviously, they're good faith estimates. We never guarantee that anything is going to cost anything in particular, but what we do is we give them an idea. If you want to take this through the summary judgment phase, it's going to cost you X. If you want to take it all the way through the trial phase, it's going to cost Y. If you want to simply engage in some negotiations, it's another cost. Best thing to do is to break it down into the smallest possible component parts. Provide that to the client. It's almost like a cafeteria. What do you want to eat today?
Yeah, that's one of the biggest takeaways I took from your book was to get realistic budgets and project estimates, and then embed those in your billing platform so that the next time the issue comes up, you can select the same items from the menu, and you'll know roughly how much they should cost.
Right. The only X factor is this: as long as we're going to be engaged in providing services on the basis of how much time we spend, there are always going to be instances where we no longer have control over how much time we spend. Quick example, I'm in a lawsuit and I tell them that I think we're only going to need to take 2 depositions, but the lawyer on the other side says, no, we need to take 10 depositions. So now then when I learn about that, then I have to revise my estimate, say, look, we're not taking 2 depositions anymore, we're taking 10 depositions, and now this is going to cost X, whatever it's going to be. Same thing with the judge. The judge may decide that it's going to take longer to get to trial than we think. The judge may decide that it's going to take longer to resolve a motion than we think. Those things, in defense of the lawyers, make it difficult to get with a lot of precision the estimate that the client wants. The client wants a number they can put into their budget and say, okay, that's the number. So you've just got to have that conversation up front to say, here's our task-based budget, but I want to let you know that there's some things over which I have no control. And when I learn about those things occurring, I'll come back to you and give you a new budget.
Interesting thread. So in commercial contracts and M&A, maybe there's more predictability, but the
Yes,
trend is already moving toward flat fee or alternative fee arrangements, AFAs. Is that something that's starting to catch on in litigation also, or is
it
it
is.
or is it too unpredictable?
It is, but less so than on the transactional side. I've done a lot of talking with clients about flat fees, and the problem with the flat fee is that somebody is always going to feel like they're getting cheated. Whatever the flat fee is, it's either going to be something that's too much or too little based on what's actually required. And if it's too much, the client's going to feel badly about it. And if it is too little, the lawyer's going to feel badly about it. There's nothing in the world wrong with flat fees as long as everybody understands it. So I'll give you the quick story. You avoided the lawyer war stories up until now, but your time's run out. Years ago, I had a client who wanted to institute a flat fee regimen for all of the cases that were being handled by the firm. And these were smaller litigation cases, and this was a long time ago. And the fellow said, I want to pay $25,000 a case, period. That's it. $25,000 a case, win, lose, or draw. And we said to him, I said, okay, you need to understand, though, that if it's $25,000 a case and the case ends up taking 5 years, that lawyer's going to lose a lot of money and is not going to be very well incentivized to give the best possible services. And the business guy said to me, well, that's too bad, but it takes 5 years, it takes 5 years. And that's what he agreed to. And then I said to him, and by the way, you also know that if another case gets resolved with one 10-minute phone call, you still owe that $25,000. And the guy looks at me and he says, that's not fair. So you got to be able to do it on both sides. Flat fees are great as long as everybody understands that it's never going to be exactly the right amount.
Yeah, it's like the old saying that you've had a good negotiation because neither party is completely happy with it.
That's exactly right. I do a lot of mediations these days, and we always say in mediation, the sign of a successful mediation is both sides walk out thinking, that was terrible, I got a bad result. But the thing we always tell them is a month from now when it's over, they'll be very happy that it's over.
Oftentimes I tell clients to start small, just try out something as a pilot program, apply it to a limited category of matters and see if it works. So maybe that's true in litigation too, that if you start with some collection matters or some motion practices, you can limit your flat fee to that category of projects, and then as you get more experience, if everyone wants to, that process can grow.
I think that's right, and it also has the added advantage of giving you the opportunity to build up a track record with your lawyer. You've got to figure out, do I really like the way this person practices law? Do I really like the way this person relates to me and relates to the other side and what have you? And if you can do that with the smaller cases at first, then that's better than being involved in a very large case where you can't get out of it and you're stuck with a lawyer with whom you're not completely comfortable.
Yeah, that's right. If you have to fail, fail fast.
Absolutely.
Well, Ken, I want to move on in our time to talk to you about law firm management and some of
Sure.
the people issues around professional services and law firms. So anyone who spends time with you can tell that you're passionate about people, how we interact, how we solve problems together, whether adversarially or collaboratively or both. How do you think about balancing people issues, which involve personalities, reluctance to change, idiosyncrasies, with getting work done efficiently?
Step by step is, I guess, the only way to say the way I think about it. I don't think that it is possible for you to build the sort of culture that you need in a law firm if people are all working remotely. I'm sort of in the Jamie Dimon school of things. Come to work and form a culture, and then provide a good product to your clients. Uh, I think you have to begin with an accurate assessment of what the job of being a lawyer really is and what the job of being a lawyer in a private law firm really is, which is different than other venues. And so when you understand that, when you understand what it is that you're being asked to provide to the client and you accept that, then you can begin to build on that and put together the sort of team that you can then go to the client and say to the client with some degree of confidence and perhaps even pride, this is a good team. We can provide you with what you need because we understand your business and we understand our business and we understand how those two have to mesh in order to provide you with the product that you want. I think sometimes we lawyers tend to forget we are vendors. We are selling our services to clients. And in order for the client to continue to purchase those, the client has to be pleased with what it is that we are doing. Now, we have certain parameters. We can't do everything the client tells us to do because sometimes it's against the law or it's unethical or whatever. But as a general proposition, we're there to provide the client with what it is that they want. So we have to find a team that can do that and then convince the client that we're the best team to do that because there are a lot of lawyers out there.
Y- you mentioned the concept of remote work and versus in-office workplace. I want to talk to you a bit about how that may have changed or evolved since COVID. Prior to 2020, it would have been almost unheard of for law firms to accept remote work of whether it's from partners or junior associates. Now it seems to be, if not the norm, at least part of a new hybrid model. Are there projects where lawyers can work effectively remotely and still be part of a team that's productive and learning and
Sure, there's no question. In my view, COVID did two things. Number one, it showed us that this was possible. Number two, good thing. Bad thing that it did is it provided an excuse for a lot of people who didn't want to come to work and wanted to say they were just going to work from home and pretend that they were working for 10 hours, but when they were really watching Andy Griffith on the TV show. So we've got to be able to decide how you're going to calibrate that. Of course, there are things that can be done remotely. And at our firm, and we're probably a little bit more conservative on this than a lot of firms, but at our firm, there are people who work from home a certain number of days a week, lawyers who do so. But as a general proposition, the drawback that I have with that, and that I mentioned a little bit earlier, is you cannot build a business of a law firm's culture if everybody is dispersed. I just don't think you can do it. And I'm sure there are plenty of companies out there that would say, oh, no, you're wrong. We have a robust culture and we don't even have an office. God bless them. Good for them. I don't buy it. Okay. And so the fact of the matter is, yes, we do that. Yes, a hybrid model is here. The hybrid model here is here to stay. But I think you're seeing the pendulum swing back a little bit, and you're seeing more people in the office and more people understanding about why there's a value to that that cannot be uh, replicated if people are all remote.
one element that isn't talked about a lot, but that really popped on the radar 5 years ago was the concept of managing people in a remote environment. And Cal Newport from Georgetown published a really great article in the Atlantic about the downside of remote work, and he talked about the risk of difficulty in management, manager burnout, because when somebody's with you in real time and space, it's pretty easy to see what they're doing, to answer their questions that come up, what we often call the water cooler type of conversations. In a remote environment, you have to ping different people to see what they're doing. Even on a work platform like Teams or Slack, you have to affirmatively reach out and find out what's the project phase. Are we meeting our deadline? It's 2 hours until the deadline. Where are we? And it's very challenging for managers to do that type of affirmative outreach on an ongoing basis, particularly with team members who are not present. So
I
that
agree.
that concept of management really raised its head as a real challenge that has to be considered along with the benefits of remote work.
Well, and I would also argue this, 2 things about that. First of all, from the management side, there may be something that I'm sitting at my desk and I think I ought to talk to Fred about that, and I'll just walk next door and talk to him about that. But if Fred's not next door and he's somewhere remote and I've got to find a Teams moment for him or whatever it may be, I may just sit there and decide, well, it's not that important. I'm not going to do it. I'm just not going to talk to him about that. I think that that creates barriers to the volume of interplay that you have. So that's the first thing. That's the management side of it. The second part of it, again, kind of goes back to culture building for the younger person who might be sitting at their desk in a law firm and they have a question. If they can just get up and walk down the hall, there's 5 different lawyers in the next 5 offices who might have addressed that particular question. And they can just stick their head in that office and say, hey, have you ever had this come up? And if the first person's on the phone or not in the office, they can go down to the second office and do that. The chances of them doing that, sitting at their desk remotely and finding someone remotely to ask those questions goes down tremendously if they can't just get out and walk and see who's down there. So in addition to the culture part of it, there's also the informational part of it and the training part of it. I always tell folks that one of the greatest values of a law firm is you got all these lawyers around here who might have run into this problem before, and that you could just walk down a hall and say, hey, has this ever happened to you? And what did you do to it? So I think that those are some of the pitfalls of the remote work. We're going to have to deal with it. We're going to have to figure out how to use it. And by the way, in the litigation side, already all of the meetings are taking place, all the motions are taking place, all of the conferences with the judge, they're all taking place virtually now. So that absolutely adds to the efficiency and increases the things you can do. So it's a mixed bag. But I do think that you've got to have that human touch. And when you're trying to assess the development of a young lawyer or you're trying to deal with a specific legal problem, I really don't think there's any substitute for being in a room with somebody and talking to them and seeing their reactions to things.
Yeah, the two go hand in hand. The efficiency of having that know-how at your fingertips in the workplace, but also, as you just said, the development and the advancement of these younger lawyers who may not have the chance to learn unless they have somebody who can tell them and teach them.
Right, somebody to ask.
In fact, I said I wouldn't wave anything in front of the screen for our viewers, but this weekend's Wall Street Journal had a front page piece in the business
All right.
section on that very topic.
Yeah, I
Your
saw
bo-
that.
your boss is too busy to see you now. How do young lawyers and young paraprofessionals develop that know-how, develop those connections, and build those relationships if the manager or the partner is too busy to see them?
Or is not present. What if the manager or the partner is working from his or her home? Then you can't do that because it's already difficult when you're the younger person to go to the more senior person and say, hey, I've got a question, hey, I've got a problem, or this, that, and the other. It's doubly difficult if they're not present for you to do that. It's a lot harder to call somebody up or to ping them than it is just to stick your head in their office.
Yeah, and my fear is that leadership and mentorship may suffer alongside of that.
Well, I think it will because you're also struggling with the thing that's always been in place long before any of these technology issues, and that is, and we've all gone through it, the notion when you're a younger person that you don't know anything, and that if you talk to somebody, they're going to realize that you don't know anything, and therefore you don't want to ask that question, but it's going to reveal that you're really an idiot. And so you've got to get over that. And if they're not there to do that, there's even less chance that you'll get over that. I always tell our young lawyers, don't worry about that. We already know that you don't know anything. Go ahead and ask us the question. But it's a hard thing to get past. I went through it. I'm sure you did as well.
Yeah, I tell the students, always make sure to ask more questions than you're comfortable asking.
Yeah. Long time ago, I was at some dinner and somebody was giving a speech which was not very good, but this part of the speech was great. They said, just remember, growth and comfort are not compatible. And I've remembered that for a long time because I think it's very true. If you're going to grow, you've got to do uncomfortable things, including asking those questions.
For sure. So, Ken, we've talked about remote work in the workplace. How about in the court systems? You're involved both in the litigation and the court systems, as well as with private arbitration and mediation. How is remote presence working in those spaces? My limited experience from doing a couple pro bono projects is we've still got a ways to go.
There's no question we have a ways to go. It's kind of a multi layered answer, so I'll give it to you in layers. How is it working? It's working more and more prevalently in with regard to meetings with judges, with regard to motion hearings, not so much with trials. During the height of COVID itself, we had a few trials that were being done virtually. So it's being done more and more. How's it working qualitatively? Not very well. Taking a deposition via Teams is awful. Conducting a hearing via Teams is awful. I serve as an arbitrator. Conducting an arbitration via Teams is awful because it's just clunky and you don't have the ability to see what people are doing and how they're reacting and what's going on. And it takes 15 minutes to share the screen and put up the next document and this, that, and the other. So I will tell you that it comes in handy when you've got a case like I did last week where one of the clients was from Washington State and one of the clients was from Illinois. So we had to do it remotely and we had a 3-day arbitration and it went okay. Would it have been better and more efficient if everybody was here? Of course. But those people didn't have to fly to Atlanta or whatever place we were going to do it. They didn't have to bring all the documents to those places. They didn't have to bring all the witnesses to those places. So I will grant you that there are certain efficiencies associated with the litigation process being done virtually, but it is still, at least in my opinion, not going to be able to replicate actually being in the room with the witnesses, with the judge, with the arbitrator, and what have you.
Yeah, it may be the case that it has to evolve in stages like you've described, from motion practice and telepresence for calendar calls and things that are more perfunctory, but then culminating in a type of a forum that involves real sophistication and you know, hands-on interaction.
I think as a practical matter, what may happen in that regard is that you're going to end up with a system where the only things that get done in person are the things that are the most expensive things where you're willing to pay for all of that. And when you can do it more cheaply remotely, in the smaller cases, they're going to do that. We see that already sometimes. And of course, that leads to a lot of cases settling, which is a whole other question. But the fact of the matter is, there are price considerations in everything that we do here. What I do is civil litigation, which means most of the time we're talking about money. And so people have to look at it as an investment. And do I want to invest this much in a real time hearing or do I not want to invest that much? And so Ken Menendez comes to me and says, if you do it virtually, it won't be as good. But the guy says to me, well, that's okay. It's only going to cost half as much. I can live with that. That's their decision to make, as long as both sides agree and the judge or the arbitrator agrees.
Yeah, there's a concept of good enough that is starting to embed itself even in consumption of legal.
You couldn't be more right. And I have seen that increasingly over the past 10 or 15 years where you talk to the client and it's almost like going to the client. In the olden days, you'd be talking about the best car, that would be a Cadillac. And you would say, do you want to buy the Cadillac? And they would say, no, 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 no. The Dodge over there is just fine with me. And you say, but you know, the Cadillac's better and you'll be safer. And no, 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 no. The Dodge over there is fine with me. And that's what I want to pay for. That's their choice. The only thing that we ask in that situation is later on when the Dodge breaks down, don't say, hey, how come it broke down? When we say, well, you bought a Dodge. And apologies to the Dodge people.
Yeah, and the model rules, candor, communication, competence, those things when we're upfront about them and we discuss them in advance, that then the client can make the decision on an informed basis.
Yes, and 9 times out of 10, the client will do that, and they really appreciate you talking to them about those things up front. I can't tell you how many times I've had those conversations with people, and they will say, "Gosh, usually the lawyer doesn't talk about this, but you've got to talk about that, and you have to make sure that they understand what's going on." And it's just a matter of developing that relationship and that trust, so that with any luck, if things go bad at the end, they don't come back to you and say, "Well, hey, how come this happened this way?" And you have to say, well, remember we talked about X, and if they're good folks, and most of them are, they'll say, oh yeah, I remember that. Every now and then you get one that'll say, no, we didn't talk about that.
Yeah, there's no substitute for trust, and communication is a key to building that relationship and that trust.
Trust but verify.
Ken, one final point on employee and lawyer development. As we have particularly young lawyers who may have less time in the office personally, what are some ways they can develop their skills to make sure they're fully engaged and learning and growing in the practice of law?
I'd say two things pop into my mind. Number one, read. Read everything you can get your hands on. Read everything legal and non-legal. Learn how to distill that information. Learn about all of that. And then the second thing is get out and get involved in the community and learn how to be a communicator. Learn how to be interested in the other people that are around you. Learn how to talk to people. It is remarkable, even at this stage, how many lawyers go through college and then law school, and they are book smart to beat the band, but don't have the interpersonal skills to communicate the knowledge that they have to the client. And so, and that's partially because what you're asked to do in college and in law school, you're not asked typically to get up and learn how to talk at a cocktail party, but it's important to be able to do that, because if you don't do that, you're going to end up as one of those very, very smart lawyers with very, very few clients.
And I've found, Ken, in the sort of latter half of my career, um, communicating, teaching, and giving back to others is a great way to reinforce, learn new things, and develop into a lifelong learner.
It's true. It's true. I think that we have to guard against that as we get more seasoned in what it is that we're doing, because remember how it is that you used to do it. And, oh, well, the old ways will always work. Well, they won't. The old ways were typewriters and not email. That ain't going to work anymore.
Well, Ken, it's great to hear the candor and refreshing enthusiasm you bring to the practice of law, and I know your clients appreciate that too. And as our time's starting to wind up here, I want to ask you if there's one piece of advice you'd give to our listeners, particularly those who might be working with law firms or thinking about engaging a law firm for a project. Um, how would you advise them to make those decisions?
If it comes to a younger lawyer trying to make a decision about what they're going to do, what I would tell them is to find two or three different lawyers at different stages of their career and just ask them what they do on a day-to-day basis, on a week-to-week basis, and see if that's something that you could see yourself doing. And you might look at the younger lawyer and say, well, that doesn't look like fun, but the one who's 10 years out, that looks like fun, and the one who's 20 years out, that really looks like fun. Uh, Talk to people who are actually engaged in the practice of law in the fashion in which you plan to practice law. If you want to go into a private law firm, talk to private law firm lawyers. If you want to go work for the government or in-house, talk to people who do that. But talk to people who are actually engaged in the thing that you're planning to do, to see what it is that they have to say about it, because there's really no substitute for the experience of having gone through it. So that's what I would say to a young lawyer. The other thing I would tell them is keep your sense of humor.
Well, Ken, as Bill Burnett and Dave Evans from Stanford say in Designing Your Life, that sounds like a really good way to design one's future career and ways to intersect with the practice of law. Ken, as always, it's a great pleasure to talk to you. Your views are refreshing and really give me an enthusiasm for the way that law is being practiced in our community. Thank you for
Well,
joining us today.
you're most welcome. You're very kind and overly kind, but thank you. It was a lot of fun. I enjoyed speaking with you and hope somebody was able to get something a little bit helpful out of it.
Fantastic. And to our listeners, thank you for joining us today. Make sure to subscribe to this podcast if you enjoy the content on your favorite streaming platform. And until then, this is Charles Bowen for the Legal Pathways Podcast.